The Americans with Disabilities Act was signed into law in 1990 by President George H.W. Bush. This law was passed because people with disabilities were being excluded from participation in society. Without equal access to public spaces and businesses, disabled people were marginalized because they were excluded from full participation and employment. Prior to the passage of the ADA, it was the practice for many families to hide disabled members out of sight. Disabled children were often placed in asylums or houses of refuge, which were fortress-like juvenile centers. Some were also placed in what were supposed to have been vocational training schools like the Preston School of Industry, which was opened in 1894 in Ione, California. Schools like this were used to house abandoned, delinquent, or incorrigible youth. Overcrowding, child abuse, malnutrition, and filthy living conditions eventually forced the state to close these institutions. It would not be until after World War II that large numbers of disabled veterans began to complain about their lack of access to public restrooms and buildings like the public library and courthouse. Since cell phones had not yet been invented, payphones were often out of reach for people in wheelchairs. Since there were no wheelchair ramps, it was difficult for physically disabled people to cross streets. It would not be until 1973 that Section 504 of the Rehabilitation Act was passed. This law forbid any organization that received federal funds from excluding or denying individuals with disabilities the equal opportunity to receive program benefits and services. One of the biggest changes that occurred was that public schools were now required to admit handicapped students and to provide equal opportunities of education for everyone. When the Americans with Disabilities Act was finally passed, the ADA made it illegal to discriminate against people with disabilities within the areas of employment, public accommodation, public services, transportation, and telecommunications. This law applies to any employer with 15 or more employees. Not only are employers not allowed to discriminate with their hiring practices, but they are also required to provide reasonable workplace accommodations that are designed to help the employee do his or her job. What is a reasonable accommodation? Under the ADA, a reasonable accommodation is any modification or adjustment to a job, the work environment, or the way things are usually done during the hiring process. For example, for an autistic person who was working in an office, a reasonable accommodation might be to move their desk away from a noisy high-traffic area to someplace that's more quiet and secluded. Instead of requiring an autistic person to physically attend a noisy and crowded meeting, a reasonable accommodation would be to allow this person to virtually attend the meeting. An example of an accommodation that would not be reasonable would be to expect an employer to build a restaurant with a private chef so that this employee would not have to eat with other workers in the company cafeteria. Another example would be if a supermarket cashier said that he or she didn't want to work with customers. Since working with customers is what a cashier does, asking to not work with customers would be completely unreasonable. If you are disabled and you want to ask for an accommodation to help you better do your job, you will either need to speak to your immediate supervisor or you will need to talk to someone in human resources. While an employer does not have the right to ask for your complete medical records as a way of verifying your disability, they are legally allowed to ask for a letter from your doctor as a way of documenting any request for an accommodation. If you choose not to share this information or do not actually have a medical or clinical diagnosis, the employer does not have to give you an accommodation. According to the ADA, a self-diagnosis is not legally recognized as a disability. A case precedent for this dates back to 2014 when a veteran who was employed by Veteran Affairs asked for an accommodation because she was not able to meet the performance standards of her job due to an issue with post-traumatic stress disorder. Since she had self-diagnosed her PTSD, her supervisor said no. In a later trial, the court ruled that a self-diagnosis is not recognized as valid. The judge said as a matter of law, in order to qualify as an impairment under the ADA, the plaintiff's depression and anxiety needed a diagnosis from a medical professional. Shortly after the 2022 school year started, a severely autistic student was placed in my class. According to his IEP, in addition to teaching him culinary arts, I was also supposed to work with him to develop his social skills. Since I myself have autism, this student was stressing me out because he would sometimes start screaming in class. When I asked my principal if this student could be assigned an aide, I was told that his IEP, his individual education plan, made no provision for having a personal aide. Since I had filed my disability with my district's Office of Accommodations and Compliance, and since the student's IEP required me to teach social skills, I requested that an aide be assigned to my class as a reasonable workplace accommodation. After some discussion, the principal agreed. The aide has been wonderfully helpful. The teen has stopped screaming and my job has been far less stressful as a result. What should you do if your employer will not give you a workplace accommodation? The EEOC, the Equal Employment Opportunity Commission, is responsible for enforcing disability rights under the Rehabilitation Act and the ADA. If your employer will not provide an accommodation, you could contact the EEOC for a review of your situation. If the EEOC agrees that an accommodation is needed, they could mediate with your employer. In some instances, they might also take your employer to court. Under the ADA, it is illegal for an employer to retaliate against an employee who has requested an accommodation. If you believe that you are the victim of retaliation, you should document this experience. Write down what happened. Include the date, time, and location. Identify who was there and what was said. If you were sent an email or a voicemail, keep copies for your records. Contact the EEOC and share your documentation with them. If they find your case credible, they could start legal proceedings against this employer. In September of 2021, the EEOC sued JDKD Enterprises, which manages several McDonald's franchises in New Jersey. The lawsuit alleges that JDKD fired an autistic cook in New Jersey 2 months after they bought the franchise that he had worked at. Even though the cook had been at this store for 37 years, he was allegedly fired for not being normal. The EEOC sought back pay, compensation for emotional distress, and reinstatement in his job. Since the former employer refused to settle, this lawsuit will be moving forward. It will be interesting to learn what happens. It is admittedly not an easy thing to advocate for oneself, but unless we learn to speak up for ourselves, who else will advocate on our behalf?
If you found this video interesting and would like to support this channel, please click on the like and subscribe buttons. If you have thoughts regarding other topics that I could address in a future video, please feel free to add your suggestions to the comments below.